When it comes to planning for your future here in Washington state, you don't actually get to choose if you have a plan. That choice is already made. The only question is, whose plan is it going to be? The one you carefully create for yourself, or the default one the state has already made for you?
Let's just jump right in with a really important question. If something happened right now and you were unable to speak for yourself, who would make the big calls, your most personal decisions? If you don't have your own plan, the answer is picked by a rigid legal formula, not necessarily by the person you'd actually trust.
So you can really think of this as choosing between two completely different paths laid out by Washington law. First, there's the default path. That's what happens when you do nothing, and trust me, it can get messy. Then there's the proactive path, where you take the wheel.
So what does it even mean, this default path? Well, it means that if you don't have a plan, the law just gives you one. It assigns you a legal framework that's basically a one-size-fits-all t-shirt. And by its very design, it can't possibly account for your family's unique situation or what you'd actually want.
All right, so let's pull back the curtain on this default plan. We're going to see exactly what it looks like, especially when you're incapacitated and can't make your own healthcare decisions. This is where things can go sideways and fast.
Okay, so what you're looking at here is the state's pecking order, basically. It's a super rigid hierarchy, like a waterfall. A hospital has to start at the top, at number one, and work their way down. They can't skip anyone. So first, a court-appointed guardian. If there isn't one, then a power of attorney agent. Then your spouse, then your adult kids. But you see that word in parentheses next to adult children? That's a big deal. And that little word brings us to what I call the unanimity trap. This is a huge legal snag in the state's default plan that causes an incredible amount of grief and conflict for families. So here's what that legal speak actually means. Let's say you have 3 adult children. The law says all 3 of them, every single one, must agree unanimously on every single medical decision. If just one of them disagrees, for whatever reason, the entire process grinds to a halt. It's a total stalemate. No decision can be made, which legally paralyzes the doctors and often forces the family into a public, expensive, and heartbreaking court battle just to get a guardian appointed.
Okay, that sounds pretty awful, right? But here is the good news. There is a way out. This is where we get off the default path and onto the proactive path. Washington gives us very specific legal tools that let you completely override these default rules and keep control.
The single most powerful tool is the durable power of attorney for healthcare. The word durable just means it works even if you're incapacitated. Simple as that. In this document, you name your healthcare agent, the one person you trust, your point person. Signing this one document elevates your chosen agent all the way up to priority level 2, right below a guardian, and it lets you completely sidestep that unanimity trap with your kids. Now, a lot of people mix up a power of attorney with a healthcare directive, which is also known as a living will. And this comparison right here is the absolute best way to understand the difference. Think of your power of attorney agent as your team captain, a real person who can think on their feet, adapt, and handle any medical situation that comes up. The directive, on the other hand, is your playbook. It's a static set of instructions that only comes into play in very specific end-of-life scenarios. Honestly, you want both, but your team captain is the one who's going to be running the show. And then we have something called a POLST. It's really important to know this isn't a planning tool for everybody. It's an actual medical order, usually for people with a serious illness. It's printed on bright green paper for a reason, so first responders can't miss it. When paramedics show up, they are legally required to follow the POLST, period. It's a critical tool for the right person, but it absolutely has to be part of a coordinated plan. So, let's say you've got your healthcare sorted out. That's fantastic, but we're not done, because life is about more than just medical decisions. The state's default plan has some other really dangerous gaps when it comes to your money and your final wishes. Let's talk finances for a minute. Yep, you guessed it. Just like with healthcare, the law has another default trap just waiting to spring on you if you haven't planned ahead. This one is a doozy. It means if you name, say, your 2 kids as your financial agents, and you don't add specific language to change this rule, they both have to sign every single check. Imagine one is on vacation, or they just disagree on paying a bill. Your finances can be completely frozen. A well-drafted document totally avoids this by just saying they can act on their own.
This next point is so important, and most people have no idea it exists. So you have one person in charge of your healthcare, right? Well, at the exact moment of death, all of their legal authority vanishes. Poof, it's gone. Then, a completely different law with a different hierarchy kicks in to decide who's in charge of your funeral. This could mean that your partner who managed your care for years is suddenly powerless, and an estranged family member could legally swoop in and take control of everything. It happens. And finally, there's one more financial curveball that's pretty unique to Washington, and it catches a lot of families completely off guard. And that is the state estate tax.
So you might see the huge federal estate tax exemption. I mean, it's over $13 million. And think, phew, I'm totally in the clear. But you got to look at Washington's number. Our state has its own separate estate tax with a much lower bar. This creates what we call a tax gap, where many Washington families end up owing a pretty significant state tax bill even when they owe zero to the federal government. And again, the default plan offers absolutely no help here.
So, after hearing about all these traps and gaps and hidden rules, what's the solution? Well, the key is to understand that a good plan isn't just one document you download. It's a coordinated portfolio of documents. They all have to work together to keep you firmly on that proactive path.
This is what that comprehensive, proactive portfolio looks like. You've got separate, powerful documents for your healthcare, your finances, your end-of-life wishes, and, this is the crucial one, your funeral arrangements. That's how you close that conflicting hierarchies gap we talked about. Each document is a specific tool designed to plug a specific hole in the state's default plan. This timeline really brings it all home. It shows how legal authority is like a relay race, not a sprint. The baton of authority passes from you to your agents when you're incapacitated, and then, instantly, to a different set of people with different jobs right after death. A proactive plan makes sure that every handoff is smooth and seamless, with no gaps where the state's messy default rules can jump in and create chaos. So there you have it, the two paths. There's the default path, designed by lawmakers in Olympia, and there's the proactive path, designed by you. The truth is, you're already on one of them right now. The only question left is, which one will it be?